open. The light will come down. Celestial choirs will be singing.
Well, tonight we have a glimmer of hope, and it comes from a federal judge in Brooklyn. District Judge Nicholas Garofis ruled that the federal government must establish probable cause before collecting a person's cell phone information. Now, the ruling came after the U.S. Attorney's Office attempted to collect 113 days of cellular location data from a man who was charged in a criminal case. And the Attorney's Office argued that they had the right to get the data from Verizon under the Stored Communications Act, which gives law enforcement the right to gather that data without a warrant if the records are, quote, relevant to an ongoing criminal investigation. So in other words, the government thinks that cell phone users don't actually have a right to privacy because when they sign up for that service, they're letting a third party receive that user information. But Judge Garofis ruled against the U.S. attorneys, invoking the Fourth Amendment. In his decision, the judge wrote, while the government's monitoring of our thoughts may be the archetypal Orwellian intrusion, the government's surveillance of our movements of a considerable time period through new technologies, such as the collection of cell site location records without the protections of the Fourth Amendment, puts our country far closer to Oceania than our Constitution permits. And you know what? I couldn't have said that better myself. Finally, somebody within our country's judicial system seems to agree with what I've been arguing all along. The Fourth Amendment was put in place for a reason, and the government has been trampling all over it ever since it's amped up its national surveillance state. So I say Judge Garofis' ruling, which actually upheld an individual's right to privacy, is a true glimmer of hope.